This week, I'm trying to kind of go back into this idea of the new forms changes that are coming up. And with the question of the week last week, it kind of reminded me of what's coming down the pipeline for possession. So today's topic is going to be occupancy and possession with reference to House Bill 1070 that's going to be effective July 23rd. All right, so rental agreements. Occupancy agreements, or what I think of as possession agreements, are a crucial part of our business, and knowing the responsibility of buyers and sellers and their roles can make all the difference in the world if something goes south. Possession is at 9 p.m. on the date of closing, unless otherwise agreed. When you're changing the hour of possession, it can easily be modified to reflect that, but it's when we start modifying days or weeks of possession that we need to be aware and use proper forms. So we'll be looking at the pre-close, post-close, rental agreements, and talking about the new bill that is excluding the rent backs in the Landlord Tenant Act, HB 1070. Okay, so possession is, just a refresher, before anything that's done before the closing date, you have to use a 65A for possession. After the closing date, we will be using 65B. And if it's just a modification on the closing time, there's no additional form that's needed, as most of us already know this. And it can just be notated somewhere in the contract or on this line. So pre-closing occupancy. Every single one of the Northwest MLS forms warned completely against using pre-close or post-close occupancy, basically anything other than just transfer ownership and possession and occupancy that the date the contract says. There's risk in everything, but the idea is to try to minimize the risk as much as possible. So the best way to do that is by putting a dollar amount of some type as the rent. If there is a rent charged, then there is like a complete rental agreement. There is more recourse than having a $0 amount. So even if it's $1, put in a rent dollar amount of some type. This is a snippet that is in both the 65A and the 65B. Both 65A and B have a termination timeline on them. You need to have a date on that timeline. And when the new House bill comes around in July, that timeline, in order for this to be exempt from that timeline, that can be no longer than 3 months. So keep an eye on your timing. It also doesn't take effect until July 23rd. So if you have a closing coming up and it's closing after July 23rd, I would strongly suggest signing your rental agreement after the 23rd. So it applies to the new laws that take effect. Anything signed before the 23rd doesn't have the protection of those new laws in place. Part of the idea with the pre-close and post-close forms too is keeping the property insured. So without these, we know that the seller is responsible for the house until closing date. Buyer takes responsibility after that. If a tree falls on the house before closing, it's the seller's responsibility. If the tree falls one day after closing, it's the buyer's responsibility. So this is related to all things like that. In fact, they even have a clause in here that says bodily injury, property damage, theft, loss, damage to the tenant's personal property. So for the pre-close, if a buyer wants to move in their items before the closing, the snippet in here says that the landlord is not responsible for the damage caused to their belongings. Utilities are also prorated at closing. So in both the 65A and B, there is verbiage that shows who's responsible for which utilities. They can't make modifications to the property without permission. And then there's the clause in here for the, if it should go to court, in both of those two. They're both also not able to be subletted. So these, what, 1, 2, 3, 4, 5, 6 things right here are going to be the same on 65A and 65B. Post-close also, or sorry, delayed occupancy also, you'll want to put a dollar amount. And I was always told that the dollar amount is really just for recourse to kind of go back and show that it was truly a rental agreement. And I don't do a lot of rentals, so I can't speak on a very deep level as far as what that means or the legalities behind that. But I do know that if there is a dollar amount in there, then it gives them more power to enforce the things that are on here. They're taking in a rental occupancy, not a tenancy, even with no rental. And right now until July 23rd, even tenancies with no rentals have landlord-tenant rights. So just covering our own behind, make sure we put at least $1 in that place. And again, make sure the term has an ending date, because if it doesn't, it's essentially like putting no closing date on a purchase and sale agreement where it can't be enforced. So just a reminder to put the ending date. Wanted to circle this one because Seattle has, for the last couple years, especially around COVID and what the changes were back then, they've kind of been creating their own laws. So if we are doing any sort of rent back or pre-occupancy in the city of Seattle, they kind of dance to the beat of their own drum. And although we have large umbrella laws that are going to take effect for the whole state, they still like to kind of be their own person there. So take extra caution if it's in the city of Seattle, and make sure you know and your client knows where to find the Seattle copy of the Landlord-Tenant Act and the state copy of the Landlord-Tenant Act if they use this form. I haven't read the Seattle one. I'm afraid to. Okay. There are things you can add. Basically, the Northwest MLS has a pretty strong stance that nothing on either 65A or B should be modified in any way. So just check the boxes that are on there. And if you need to change anything, they have separate addendum that you can attach to this. One of them is the pet addendum if you want to make rules about pets, which pets are and are not allowed. I just brought it up to light because these forms are kind of obscure and not used all the time. And then the second form, must be later in my slides. The second form is just a blank form, kind of like a 34, but it's specifically for doing rent backs. So when you're thinking of rent backs, one of the first questions to be thinking about is how long after closing are they going to stay? The HB 1070 only protects that buyer, the landlord, if the rent is less than 3 months. So if it's just a few weeks, they have the protection of this act. If it is longer than 3 months, it does not apply. So if it's a long, long time, I mean, Northwest MLS form says 6 months, but actually they recommend using this form if it's over 1 year. If you're doing a rent back for over a year, it's considered a rental or a lease agreement, and they want you to use this form instead. So long-term rentals, rent backs should have, and I am covering the form, sorry, this form 68. I don't know if anybody has ever used this form because typically we don't do this with a regular purchase and sale. In fact, most of the time, we're at the mercy of whatever the lender is going to decide is appropriate or allowed when it comes to renting back a property.
Jen, I use this for when clients are looking for rentals in general.
Okay.
Yeah.
Okay, good. Do
It's
you
pretty
have
simple.
anything, any insight on this form that you think would be important to touch on? Because I actually don't use this form.
Yeah, no, I mean, it's pretty straightforward. Just a reminder, if clients are choosing to rent the property, just understanding that, they're not as protected as tenants are anymore. So there's, just letting them know that they need to make sure that they, clarify everything that they're expecting on the rental.
Mm-hmm. Do you use this with the rent checklist, that 4-page checklist that shows quality of the property?
You mean the walkthrough?
The walkthrough, yeah. I'm sorry.
Yeah, I actually use Zillow's walkthrough. It's better. It's cleaner.
Have you
I
ever?
think.
Oh, sorry, I didn't mean to cut you off.
Oh, that's okay. I was
Have you
gonna say.
ever?
Finish. Okay, I'll listen.
Sorry. I was going to just ask you if you've ever done the walkthrough form with a shorter term rent back or just with longer term.
I have done the short. So I had sellers who rented back. The buyers allowed them to rent back. And it was so thorough, and photos were taken, and a large deposit was held because buyers were just concerned that damage was going to be done to the property, even though it was being sold as is, and they waived inspection. But it was the most thorough walkthrough. It was probably like 2 hours of checking everything. It was crazy.
Okay. And then you said Zillow has a form for the walkthrough that you like.
Yeah. So if you go on to the Zillow website and you pull up the rental, down at the bottom of the page, it's called resources. And if you put your Northwest MLS rental, Zillow will catch it. If you're doing both if you're selling it and listing it for rental, Zillow will only capture the sale of the property, not the rental. But
Okay.
down below, there's a resource, and down there's Zillow application forms and the walkthrough. And it's more simple and less tedious, but it's still just as thorough, and you can still take pictures. I just think the walkthrough we have with Northwest MLS is very tedious, and it doesn't apply to everything.
Okay. I was just going to pull up the one that we have on the Northwest MLS.
Yeah.
So, I mean, this is pretty thorough. I'd love to look into Zillow's actually, since you said that. But I guess here is a reference of a walkthrough checklist that's accessible to everybody from the Northwest MLS. I mean, I think it's a great idea. I really do, because you do legally, in all senses, become a landlord the date that closing happens. So you're responsible for all these things. And although there's, they're required to get insurance, and there are things that they are required to do. It just, I think, gives a one more layer of protection for that buyer who now becomes a landlord, even for a short amount of time. And this one is pretty thorough. I do like the idea of taking pictures, though. I think that's never bad. That's an excellent idea.
Can you require them to get insurance, or is it something that they just?
This form actually says they're going to get insurance.
Well, the form says that you can click on the box to say that they're required to, but you don't have to click.
So the landlord, oh, you mean for renters insurance? The tenant is just advised to get renters insurance covering.
Yeah, it just says advised. It doesn't say mandatory.
There's a place on that form though that says that the renters, if the landlord clicks on it, the tenant has to provide a copy of their insurance.
Yeah, I did. I'll pull up the entire form because I actually only took snippets from the form itself. So here, 65, here's 65B. So this is an entire section I left out, but there's an other column right here. And you said on the check, on the walkthrough one is where the insurance is, Scott?
No, it's on this page. It's on this form. You have to scroll up a couple of pages up.
This is the
Scroll
end.
up. Yeah, scroll up. This is the seller occupancy for the short term. This is not for the long term.
Oh, I'm sorry. I thought you meant the short term. My apologies. So the long term, the lease agreement, 68. So Russ, I guess if you're thinking for the short term, you may have to write something separately that says that they will be purchasing insurance, because that doesn't have the option.
So it's only an option on the long term.
Long term, here's long term utilities. They can, the security deposit, maintenance, carpet cleaning, late charges, non-refundable fees, renter's insurance right here, number 12. But no, it's not an option on the short term. So if the short term is something that you need to require, which you may want to, you may have to write it in the other column because there's no checkbox for that.
Although if you think about it, if the seller is staying there, so it's the seller that's staying there, right? Because they're
yeah.
So I guess their insurance ends once they close on the property. Never mind.
So in that case, I guess it may be advised that they do get insurance. Because like I said, I didn't see anything in here, but this is the longer term lease agreement. I just pulled up this right here because the 68C is where you add all that additional verbiage. Like I said, the Northwest MLS does not want anybody making changes on 65A or B. There is a small other column to add a few things, but this form was specifically made to go and coincide with those forms and add, other clauses that you might want to put into the contract. So I guess, Russ, I would add it to the blank column in the 65A or B, if it's just insurance. Or, you could put this in there, maybe not necessary if you have just that blank form or blank space at the bottom of the form.
Can you use the 68 for short term, or does it have to be the 65B?
So it's really, the form was made for long term. I don't know, I'd have to look into why you would use one over the other. I just know that the forms were made specifically for the reason of short term versus long term. And in doing this, well, this one right here says 6 months minimum. In the 6 month minimum rental agreement, it doesn't apply to the new law change. So this is not exempt from the new Landlord Tenant Act taking effect in July. This is going to be a true rental agreement. You can't do anything within that time frame that you've agreed. You can't kick them out. You can't give notice. If you have this month to month, or if you have a lease agreement for a certain time frame, sure, you have time to give the notice of I'm sorry, I'm getting sidetracked. You have time to give them the 60-day notice to vacate for this. The whole idea for the short term was to just change the occupancy switching time. This is an actual agreement. So I think that anything less than 6 months, it's too short to take effect to most of the things that are put in this agreement anyway. If it's a 3 month and you have to give 60 days notice for them to terminate, or 60 days notice to vacate. That's such a short time frame that you probably don't always have the luxury of having that time. So I don't know, Kati, have you ever used this lease rental for a short term?
I want to say one of my clients as a buyer, this was because it was more thorough. And it was still when COVID regulations were still in place. So I think this was being used to protect the seller.
Yeah. Well, there was a 120 day payer.
No, 90 days.
Was it 90? Okay.
Yeah. So I haven't heard that it's changed to 60 days. I've heard that it's still 90 days. So I don't know. So if it's changed back to 60, that's great. But
it has changed. And it's going to be changing again. And there is a podcast that I'll probably refer everybody to, because the lawyer that is, kind of doing these podcasts is excellent. She's very, very smart. I just, it's going to take a few times watching and a lot of notes to get everything down. And it just kind of encompasses the Washington state law, not necessarily county laws, because you have the state restrictions and then the counties have their own restrictions. And King County specifically started making up kind of their own, they have their own things they want to do, which is it doesn't coincide with the state all the time. So there is, after the 23rd, the main thing to remember is all of your notices have to be the same amount of days. If you give a 60-day notice for, to vacate, don't give any other notices that are any other time frame. Because if the court decides to take this in and the tenants don't want to move out, anything that doesn't coincide with the dates will get your case thrown out. They won't even look at it. The timing is going to change after the 23rd. When the form change comes out, I believe the form change is going to have it written in exactly how much time you need to give them. So the timing, I don't know if that should be too much of a concern right now because of the change coming up next month. Okay. So with upcoming 1070, bullet point things to just know about it. The rental agreements have to be month to month. They cannot be longer than 3 months. At the end of that rental time, your landlord cannot accept any payments at all. They cannot cash checks. They cannot take any money after that lease ends or after that rent back ends, because if they do, it will be considered an acceptance of month to month from that point forward, will not be protected with HB 1070. It does not remove the need for the eviction notice. It just changes the policy that on how you deliver that. The sale and the rent back agreement have to be either represented by a licensed real estate broker or a lawyer. There has to be a written occupancy agreement. So for us, that's a 65B. And it just expedites evictions if these rules are all followed. And the property cannot be a distressed property, which I'm not really sure we deal with distressed properties at all. And then it takes effect July 23rd. Okay, so here's something that's more or less like things that we deal with on a more regular basis. So the question would be, what if the buyer wants to move their belongings into the garage a week before closing? Seller's okay with this idea. How do we write this up in a contract? I lost my cursor. There it is. So technically the right way to do this is if the buyer wants to store their belongings in the home or garage or even part of the property, a 65A should be drafted. That's the pre-close occupancy. The verbiage in this form addresses the insurance, the liability. Drafting it on a 34 is not something we should do. There are too many things that are going to be left out, too many variables on what could happen. And we will likely not be able to anticipate all the scenarios that would be covered if we had just used the 65A. You can write on the 65A that it covers specific areas of the property without necessarily needing to give access to the entire thing. But that 65A is the form that does cover the needs for doing this. All right. That's all I have on the subject. Next week, there's a lot of form changes on Form 21, which are going to actually make our lives a lot better. It's really simple forms. It simplifies everything we've been doing. It makes things that we are trying to do just a normal practice. A couple things that we'll look at. I'm going to just go through the red line items, but information verification is going to change. So many agents have been crossing out information verification that it's going to be a negotiable section. You'll be able to write in the number of days that you have for information verification. And several other red line items will be coming up